of slavery sits solidly at the core of the American Civil War. But what turned a long-standing practice suddenly into the outbreak of war? Could a Supreme Court case, largely forgotten, have triggered the chain of events that led to shots fired and ultimately thousands upon thousands of deaths? I'm Tom Army. Welcome to this edition of United States History Online. Today, I'll talk about a 19th century Supreme Court case and ask you to consider why it may have had such a profound impact on the history of our American nation. Slavery certainly caused the American Civil War. But why did war break out when it did? Between 1820 and 1860, a 40-year-long span of time, Southerners and Northerners disagreed about tariff policies, the compact theory of government, and states' rights. At the center of each of these different issues sat the insidious institution of slavery. Slavery certainly drove the nation apart. However, on a specific day in 1861, the war began. What turned that long-standing disagreement into an armed conflict? Before the war, most people in the North certainly did not fit the definition of an abolitionist. Many citizens living in slavery-free states still harbored racist feelings towards blacks and indeed cared little about slavery's expansion heading westward. To pick up a rifle and risk your life fighting a war requires more than an abstract philosophy. It requires a personal affront, perhaps a challenge to one's personal sense of autonomy. In some sense, ironically, a feeling that someone wants to turn me from a free person into a slave. A little-known 1842 Supreme Court decision may have made free citizens of the North and the South suddenly feel their personal liberty had come under direct attack. That feeling might indeed rise to the level of a cause worth fighting for. In 1832, a black woman named Margaret Morgan moved to Pennsylvania from Maryland. In Maryland, she had once been a slave to a landowner named John Ashmore. Ashmore had allowed Margaret to live as a free woman, yet he never formally emancipated her. Ashmore's heirs decided to reclaim her as a slave after she had moved to Pennsylvania. Reclaiming her meant hiring Edward Prigg, a slave catcher, to abduct Morgan and her children and return them to Maryland. Prigg led a four-man assault team, and on April 1st, 1837, in York County, Pennsylvania, they successfully brought Morgan and her family back to Maryland. Outrage flared among citizens of Pennsylvania, and Prigg and his band of slave catchers were eventually captured and charged with violating an 1826 Pennsylvania law protecting fugitive slaves. A Pennsylvania court found Prigg and his companions guilty. Prigg appealed that verdict to the U.S. Supreme Court, arguing that the Pennsylvania law did not supersede the U.S. Constitution, the Fugitive Slave Act of 1793, and the Constitution's Supremacy Clause. Justice Joseph Story wrote the Supreme Court verdict in 1842. And the court ruled that the Federal Fugitive Slave Act of 1793 invalidated the Pennsylvania statute that prohibited blacks from being taken out of Pennsylvania back into slavery in Maryland. That ruling overturned the conviction and freed Edward Prigg. Now, in writing the court's opinion, Story added these words, quote, "Whether state magistrates are bound to act under it," meaning the federal law, "none is entertained by the court that state magistrates may, if they choose, exercise that authority," assisting slave catchers, "unless prohibited by state legislation," end quote. In other words, the Fugitive Slave Act still stood, but the court said only federal agents had to enforce it. Historians call this aspect of the decision the anti-commandeering doctrine. Over the next 8 years, Story's Supreme Court decision encouraged many northern states to enact so-called personal liberty laws. These laws protected state sheriffs, justices, and citizens from persecution if they refused to assist Southerners in the return of their runaway slaves. To Southern slave owners, this development felt outrageous. They saw this trend as a flagrant violation of the spirit of the U.S. Constitution. In 1850, the United States Congress passed a package of 5 laws that tried to soften the anger on both sides of the slave issue. One of these laws strengthened the Fugitive Slave Act of 1793. The Prigg decision made the passage of the Compromise of 1850 necessary. The impact of the Prigg decision rippled over a decade into the 1850s. First, the decision had forced the South to depend upon the federal government for a national solution to its problem of fugitive slaves. Many in the North saw this apparent yielding to the injustice of slavery in the South as simply wrong. Second, both Northerners and Southerners began to view the court as uniquely qualified to stem the growing agitation over slavery. In 1857, President James Buchanan and Chief Justice Roger Taney believed the time had arrived for the court to finally settle the issue of slavery. The Dred Scott decision resulted directly from this chain of events. The Prigg decision pushed both the North and the South to refine their definition of personal liberty. For Southerners, liberty meant the freedom to live wherever a free person wanted to, and to take with them their property, protected under the Bill of Rights. For Northerners, liberty equated with the freedom to accept or reject slavery, to assist in the capture of fugitive slaves, or to refuse to assist in the capture of fugitive slaves. Northerners believed government, and especially the powerful Southern plantation owners within the government, had no right to dictate their moral principles. If a person viewed slavery as morally wrong, no law should force them to aid in or condone that practice. A person's decision about slavery was a personal one. As Story had argued in 1842, the Supreme Court could validate slavery, but not expand its privileges. The question I want to ask you: was the American Civil War fought over the issue of slavery, or over the issue of whether individual citizens had the right to decide for themselves whether to support slavery or condemn it? Do American citizens today feel strongly about their right to decide moral values for themselves and resist having others dictate moral positions to them?